Chairman, members of the City Association of North America, ladies and gentlemen, I was asked to speak on the human rights situation in Pakistan, and I will speak on that. And I am conscious of Shah Sahab's criticism of the judiciary. So let me begin by saying that human rights in a country depend firstly on the laws of that country and secondly on the public interest in human rights in that country. Judges have always played, even in the United States, a very peripheral role in the protection of human rights, because they have no power of enforcing their judgments. They are at the mercy of the government for enforcing their judgments, and many judges are influenced by the fact that their judgments will be flouted if they are not backed by public opinion. Even in the United States, the judgment of two of its most eminent Chief Justices were flouted. Marshall was perhaps the greatest of the American judges. At the end of his life, 3 years before his death, he gave a judgment upholding the rights of Red Indians to their ancient lands. So, a populist president, Jackson, said, John Marshall has given his judgment, let him go and enforce it. And the court's judgment was flouted because Jackson knew that the judgment would be very unpopular with whites who were his constituency. Then, when the American Civil War had broken out, Lincoln had suspended the right of habeas corpus. The Supreme Court held his order to be illegal. The Supreme Court's judgment was flouted throughout the long years of the Civil War. And so this had a traumatic effect on the courts. You have all benefited under the 14th Amendment, which prohibits all discrimination, which prohibits segregation, and yet, smarting under its rebuffs, half a century ago, the Supreme Court of this country had upheld segregation as legal. There is no court in the world which has been totally independent. So when you judge the Pakistan Supreme Court, make allowance for it. But I'll resume my speech. The concept of constitutions after the Second World War has followed the American pattern, namely a written constitution which seeks to limit the powers of the government and a guarantee of human rights which seeks to limit the powers of governments as well as legislatures. And this year, you should have celebrated in this country the bicentenary of the incorporation of human rights in the American Constitution. Though I criticize the American Supreme Court, by and large, it had been successful in protecting human rights. And so, when India became independent, it followed the American model. And you can still say in spite of the tremendous strains to which India is subject, in spite of the civil wars raging in India, that on the whole, human rights have been protected better than in most third world countries. But all third world countries, including we, have well-drafted constitutions with guarantees of human rights. What has been the result? Whether it is Pakistan or Kenya or Zimbabwe or Rhodesia, Zambia, there are more violations of human rights in the independent countries of the Commonwealth than in the days of the British Empire. There are more prisoners of conscience in the independent countries, republics of the British Empire, than in the days when England ruled those countries. It is obvious that the reasons for such a universal failure are not simple, but the collapse of constitutions proves that constitutions and courts cannot protect human rights. You have had human rights in England for generations without any written constitution even. But that means the British Parliament is free to pass oppressive laws. And the reason why it does not is that members of Parliament know they would lose elections if they pass oppressive laws. Similarly, through long centuries of their struggle for freedom, the English people realize that in the long run, you cannot have human rights unless minorities are free to criticize the most cherished beliefs of majorities. That is why in England, you can criticize, you can ridicule Christianity, and no one will touch you. And that is why the English people could not understand the reaction to Salman Rushdie's book, which was universally condemned in Pakistan, although nobody was supposed to have read the book because its import had been banned. So you see, that is typical of the third world. Somebody whips up chauvinism, somebody exploits religion, and you clamp down laws to suppress freedom. In such a society, no courts will preserve freedom. One of the great American judges, learned hand, said, "Liberty lies in the hearts of men and women. As long as it lies there, no constitution, no law, and no courts are needed to save it. When it dies there, no constitution, no law, and no court can save it." Learned Hand's concept of human rights was based on the capitalist model of democracy. And as we are model not of capitalist democracy, but a super-capitalist democracy, why is it that we have failed where America has succeeded? I think the main reason is that all our governments that had obtained through a voting process which was never free from rigging, a majority in Parliament have assumed that they have the right to oppress the minority. Again, this is an almost universal phenomenon of the third world. And yet, almost every third world country has racial, ethnic, and religious problems. Therefore, we have to work out a definition of democracy which we should follow. And I would not presume to define democracy, because its concept has changed from generation to generation and will change. I will only try to describe it for a pluralistic society like ours, which is now rent by ethnic and sectarian strife. My model again will be the country whose hospitality I am enjoying at the moment. In his inaugural speech to the American Congress on his first term as president, Jefferson, the author of the American Declaration of Independence, said to the Congress, "All too will bear in mind this sacred principle that though the will of the majority is in all cases to prevail, that will, to be rightful, must be reasonable. That the minority possess their equal rights, which equal laws must protect, and to violate which would be oppression." Then Jefferson discussed the problems facing the country, and you would recall that the United Empire loyalists wanted a reunion with the British Crown. They were against the very form of government in the United States. So Jefferson said, "And let us reflect that having banished from our land that religious intolerance under which mankind so long bled and suffered, we have gained little if we countenance political intolerance as despotic, as wicked. And if there be any amongst us who wish to dissolve this union or to change its republican form, let them stand undisturbed as monuments of the safety with which error of opinion may be tolerated where reason is left free to combat it." The practices of the founding fathers of a country shape its political and social life for generations. Now, let us see the contrast with Pakistan. I would request all of you to buy and read Zamir Niazi's book, The Press in Chains. He points out how the Ministry of Information tried to suppress Jinnah's speech to the Constituent Assembly, which was also his last testament to the nation, because he knew he was a dying man. So the battle for those who stood between a secular state and those who wanted the theocracy began before our country came into existence. This speech was on the 11th of August, and the government, influential elements in the civil service, tried to black out that speech. It is said at the behest of the Prime Minister, but we don't know. Now I turn to Mr. Liaquat Ali's policies, because it's no use blaming only contemporary Prime Ministers and Chief Ministers. The problem is so very great because it goes back to the foundation of the country. Jefferson said that the United Empire loyalists were free to denounce the very existence of the state in which they lived. Our first Prime Minister dismissed the frontier government because it belonged to the Congress Party. Now, assuming that in the heady days of independence, it was not possible to trust those who remained loyal to their convictions, Suravadi had, in my opinion, played a more important role in the creation of Pakistan than Liaquat Ali. But for Suravadi, Bengal would not have voted for the Muslim League. What was the response of the Muslim League? First, a law was passed by the Constituent Assembly. Now you know that members of the Constituent Assembly were elected in the manner laid down by the British government under the statutes preceding the Independence Act. That was the very foundation of the country. It was in part the constitution of the country. So Liaquat Ali passed a law that no one can remain a member unless he owns property in Pakistan. Suravadi and Gandhi were working together to put an end to the bloodshed in Indian Bengal, in which they were eminently successful. But as soon as this law was passed, Suravadi rushed to Dhaka to buy a property. He was externed from Dhaka. So, an ungrateful people disqualified him from membership of the assembly. Not a single Muslim leaguer denounced the action of their chairman. Then on the third anniversary of our independence, Liaquat Ali started a pattern which goes on as described by Mr. Hafiz Pirzada. You will find this reference at page 100 of Suravadi's memoirs, but a CSP officer whose duty it was to attend the meeting has confirmed the statement to me that Mr. Liaquat Ali referred to Suravadi as an Indian dog and an Indian agent. So brand your opponents as traitors, well, what is left of democracy? Once again, nobody in West Pakistan protested. Then in the election campaign of the Punjab in 1951, Mr. Liaquat Ali made a statement which seems to me the very definition of fascism. He said, he was the president of the Muslim League. He said that a vote against the Muslim League would be a vote against Pakistan. No one in West Pakistan protested. Now, you all know of President's Order 17 of 77, under which Benazir and others are sought to be disqualified. What was the origin of that order? It goes back verbatim to a law passed by Liaquat Ali in 1948. It's a long title. Public, Mr. Pirzada should note Dorab.
Public Representative Officers
Disqualification Act. I was shocked, and my main grievance against the 12th Amendment is that it was passed in less than half an hour, and that notice of the bill had not been given to members of the Assembly, therefore the members of the opposition were not aware of it. Do you know how old this practice is? Again, it goes back to Mr. Liaquat Ali in 1948. I will read out from Mr. Hamidul Haq's memoirs. Speaking of Proda, he writes, no previous notice of the bill was given to the members of the Assembly. As no prior notice was given, I was not present when the bill was enacted. The same day, without debate, within a period of 30 minutes. Now, politicians would be disqualified for misconduct. That act can destroy democracy, so one would expect at least clear definition of misconduct. Now I'll read out to you a very short passage from the judgment of our first Chief Justice, Sir Abdul Rashid, in a Proda case. Sir Abdul Rashid wrote, it will be noticed that a large number of acts are included in the term misconduct, which are unknown to any system of jurisprudence. What is more, a great many of these terms elude precise definition. Jobbery, favoritism, nepotism, willful maladministration, and other abuse of official power and position have not been defined in this Act. But they have been reproduced first by Ayub in Ebdo and now in Precedence Order 17 of 77. I am again reading from Hamidul Haq's memoirs at page 151. Mr. Liaquat Ali Khan had started the unfortunate practice of dismissing provincial cabinets, and he had the Government of India Act amended, giving the Prime Minister power to appoint and dismiss provincial cabinets. The dependence of the provincial cabinets on the support of provincial assemblies was removed. That's a total negation of the rights of the people of the province. The amendment was made through an executive order of the Governor General without the aid of the Constituent Assembly. The change was not made public and remained in the files of the central government. Now, I am surprised not that we had martial law. I am surprised that we did not have it earlier, because the society which accepted such legislation without any protest did not believe in human rights. And with all respect to Shah Sahib, what can judges do in a society which does not believe in human rights? I showed you how the most powerful court in the world succumbed to the pressures of public opinion. But the pressure of public opinion is mild compared to the pressure of a military coup. And we had our first martial law in 1958. The alternatives before the court were to accept it as a fait accompli, to give it qualified blessings and try and control it. But of course, if you say that the courts are going to control martial law and you are unable to do that, your duty is to resign. The other alternative was for the court to meet and declare martial law illegal, but a coup which is successful will never permit the court to assemble to declare its regime illegal. Now, The validity of martial law was decided in the very month in which it was declared in a case known as Doso's case. The court followed the first alternative, and 25 years later, Justice Cornelius was questioned as to why they legitimated martial law. He said if we hadn't, the public would have supported Ayub and not the courts. I think his explanation was correct with regard to West Pakistan, but certainly not with regard to East Bengal, because Bengal is a much more open society. Bengalis are more tolerant than we were. And unfortunately, the court not only accepted martial law, which it could have on the doctrine of necessity which it had formulated a few years earlier, but it gave its blessings to future martial laws by saying that a successful coup created a legal order by which courts were bound. This was unfortunate, but the reason perhaps was that Justice Monir admitted many years later that he had advised in drafting the documents for the declaration of martial law. He said he believed this would enable him to preserve the jurisdiction of the courts for the day when martial law would be lifted. I would accept his statement, and I think his cooperation at least ensured Justice Kayani's freedom to denounce martial law as he did. Now, General Ayub only wanted two orders from the court: that the constitution had been abrogated and that no writs could be issued against the martial law authorities. If the judges had accepted the first demand, it would still have protected the citizen, because the rights which are guaranteed in your country by the 4th and 5th Amendments are not guaranteed in our Constitution at all. They are governed by the Criminal Procedure Code and the Law of Evidence. The provisions in those laws as they stood in 1958 were very fair and gave us the same protection as the amendments here. But as they did not enjoy constitutional protection, they were destroyed by martial law. And the court accepted both the concessions in Doso's case, that a successful coup means the abrogation of the constitution and the acceptance of all claims by the military authorities. Then we had our constitution in 62, which was martial law in civilian form. But Ayub was, thanks to the agitation in East Pakistan and the agitation of the National Awami Party in the frontier, forced to give fundamental rights in 1964. We had the war a year later, and fundamental rights were not restored until about 69, when in a matter of months, the second martial law was declared. All our constitutions are, if I may use that term, a rehash of the Government of India Act plus a chapter on fundamental rights. When the Government of India Act was being placed in the House of Commons, Nehru had unfortunately made a statement that the Congress party would contest the provincial elections only for the purpose of wrecking the scheme of the Act, so that the government could not be carried on in accordance with the Constitution, which was the Government of India Act. To meet this challenge, the British Parliament put in a provision, Section 93, that if the Governor-General was satisfied that the government of a province could not be carried on in accordance with the Constitution, he could dismiss that government. If you read the transfer of power documents, you will find how Lord Wavell agonized over the question of dismissing the Bengal government on account of the famine. But from 1949, Muslim League with prime ministers dismissed provincial governments if the provincial chief minister showed independence, e.g. Mr. Kuro, or if the provincial government belonged to a party other than the Muslim League. Now similarly, because fundamental rights have been incorporated, the Constitution contained the provision that if the President proclaimed an emergency, fundamental rights could be suspended. The only protection was that the period